Check this out.
Okay. Each time when I come here, I am abused. Okay. On the street and I got my swag on. Okay. Get the money, gotta get my bag on. Okay. Triple.
Imagine planning your special day that you've dreamed of since you were a little girl. You got your dress, DJ, food, invitations are sent out, only for the Lord to tell you, we accept your love, however, not enough for us to allow you to be married. Unfortunately, this was a reality for two people, Maria Fourie and Cecilia Buertenes, in the early 2000s in South Africa, where two same-sex grown women decided to get married and solidify their union. However, they were turned back and they were told they cannot get married. Hello everyone, my name is Wami Lutuli and welcome to the Graveyard Shift, where I take LLB case law that you will find in your degree and summarize it for you. Welcome to the Graveyard Shift. Let's get into the facts of the case.
All the kings had their queens on the throne. We would pop champagne and raise a toast to all of the queens who are fighting alone. Baby, you're not dancing on your own.
Maria Fourie and Cecilia Buertenes were two life partners that they had decided to take their partnership and wanted to make it a marriage. In October 2002, they had applied to make their partnership a marriage. Unfortunately, they were denied. The officials stated that the law states that a marriage is between one woman and one man. And of course, they were both women. Having heard this, they both were confused and obviously upset. And this is when they approached the Pretoria High Court to say to them, guys, this is unconstitutional. This infringes on my right to equality. The High Court looked at their case and essentially just agreed with them and said, you know what, this is wrong. Go ahead and get married. However, the government had appealed this decision in November 2004 at the Supreme Court. The Supreme Court essentially upheld what the High Court had stated, giving Cecilia and Maria a go ahead and plan their wedding. With so much excitement, they both continued to start planning for their wedding. However, the officials at Home Affairs appealed it again at the Constitutional Court and stated, excuse me, courts cannot make or discontinue or scratch out laws all willy-nilly. That is not their duty. Their duty is to uphold the acts. The only people that can either rewrite, substitute, or bring in is Parliament. This is where the case starts. Let's take a look at the legal issue that was presented to the court. The Constitutional Court had to decide three core issues. 1. Does excluding same-sex couples from marriage violate the right to equality? Does it infringe human dignity? If unconstitutional, what is the correct remedy? Should the court change the law or leave it to the Parliament? Let's look at what the court said in this judgment. Now, in an anonymous judgment that was led by Justice Ava Max, the court answered these questions very empathetically. But the exclusion of same-sex marriages was in fact unconstitutional. They had stressed that the Constitution values equality and dignity, and that any two consenting adults that want to marry should have the right to marry. Now, they had also stressed that marriage is not just a title that has just a ring to it, but it also has legal implications, legal consequences that is attached to it. For instance, spouse support, inheritance, parental rights, joint property, divorce protection, and so much more. Denying these things to same-sex couples essentially basically puts them in a second-class citizen, and withholding same-sex couples to not marry was a very harsh way that our law was treating them. The court also noted a simple principle that if heterosexual couples wanted to get married or not, that should be an open thing for same-sex marriages. They should be able to choose should they want to be married or not. By excluding gays and lesbians from marriage, not only did they violate their equality, but they also violated their dignity as people. The court had quoted Section 10 that everyone has a right to inherit dignity and to have their dignity respected. This section dismissed all the government's justification for what they were doing. It is also noteworthy that the court had rejected this notion of there is one correct form of family. Our Constitution protects diversity, not uniformity. Now, what was the outcome of this case? Having found discrimination in this case, the court had suspended their invalidation for 1 year to allow Parliament to make the relevant changes, basically to add a very inclusive wording in the Act where it was more or less more gender neutral. The court had given them 1 year, and they had stated that if this is not done in 1 year, then the Act will automatically be read as gender neutral. I would like to also correct myself by saying, when I mean the word Act, I'm specifically speaking about the word spouse. So when the court had stated that if they do not correct this within a year, they will have to read the word spouse as a gender neutral form, not in the word of one man and one woman. Fortunately, Parliament did move quite swiftly with these instructions. In 2006, in November, MPs passed the Civil Union Act. This allowed two adults to register their civil union as a marriage or a civil partnership. Deputy President Phumzile Mlambo had signed this on the 30th of November 2006, just 1 day before the court's deadline. The new law took effect immediately. And it is also noteworthy that on the 1st of December 2006, the first same-sex marriage was held, a day after it was signed. In practice, the Civil Union Act gives same-sex couple the same benefits or consequences that a heterosexual couple will receive when entering into a marriage. That being said, by the 30th of November 2006, same-sex couples had full legal access to marriage. Why does this case even matter? The Fourie case had cemented South Africa's place in the LGBTQ plus history. It made South Africa one of the 5th countries to legalize same-sex marriages. This landmark fits very well in the South African post-apartheid transformative constitution. Globally, the Fourie case stands as a powerful example of a court recognizing same-sex marriage as part of a basic human equality. Now, for the South African society, this outcome was huge. After years of struggle, loving relationships by same-sex couples were finally accepted, were finally validated, they were finally seen. This case affirmed that the South African Rainbow Nation, the law could not declare some loving unions less worthy. In this case, the Fourie case showed how South African constitutional courts has approached certain rights. To end this, the Fourie case showed us that the Constitution itself is not neutral. It actively protects those once were pushed to the margins. Equality means equal love, equal dignity, and equal recognition. Now, if this video did help you, I am 1000% happy. Should you have any questions more about this case, if you ran into any exam questions that you want me to discuss, go ahead and pop it in the comment section, and please don't forget to like, share, subscribe, and click the notification button so whenever I drop another video, you will be the first to know. With that said, I would like to say thank you and have a great week ahead. From me to you, good night, good afternoon, or good morning, and thank you for watching. Cheers. I'll meet you in the next shift.
Love yourself today, cause baby, you were born this way. No matter gay, straight or bi, lesbian, transgender life, I'm on the right track, baby, I was born